When you're hospitalized, either that agent or the guardian would make decisions for your medical care. The guardian does not have to be the same person as the conservator. So lots of times when families come in, I will tell them, if you have one child that's a nurse and another child that's a banker and they want to work together, one can be the guardian, the banker probably, the nurse, and then the second, the banker could be the conservator. Guardianships, they can be limited, or actually we can go to the next slide if that's all right, Debbie.
Oops, sorry about that.
Actually, a couple. The first one for me, I think it's slide 5. I'll continue on and we can catch up with the slides. But so guardianships, they can be limited, and same with conservatorships, limited or general. And what that means is the court in its order can carve out certain responsibilities that you can or cannot do. For example, we have a client from way back, and she has a guardianship. She's had a guardian appointed for her. However, it's a limited guardian that only can say where she lives. Unfortunately, she has an alcohol problem, but she's retired from a federal job, so she has a pretty good income in retirement, and her spending was not an issue. Just the issue was when she was making bad decisions at home to the point it was risking her life. So that in that case, the guardian is only in charge of making her live in an assisted living facility so that she can get the medical care that she needs, but she's still in charge of her own finances. When we get to it, I've switched to conservatorship of adults now. So when I said the guardianship is over the body, like a parent is over a child, conservatorships are over the estate or the checkbook. I make the same stupid joke and nobody ever laughs, but the guardian is over like I am over my son. The conservator is over the checkbook like my wife is over me. So I can't spend any money without her looking at it and approving it. The replacement for a conservatorship is a power of attorney. And again, Jessica will talk about those later, but if you do not have a power of attorney, and you're incapacitated, people can't make decisions for your financial affairs, and that's paying bills, selling property, entering into contracts, things like that. Just like the guardianship, they can be limited or general, meaning I think we've caught up with the slides now. So if a conservatorship, and we're on the last one here, can be limited, and which means that, for example, we have someone that he did not need a guardian. He kept on falling for these sweepstakes. Somehow you get on a mailing list and everybody and their brother knows that they can send you a piece of mail and you'll end up sending them money. So he could have conversations just like I'm having now. You could meet him in the store and not know anything's wrong with them, but if you send him a letter to send him money, he would send you as much money as you asked for. So in that case, a conservator was appointed, but only, I'll say for lack of a better term, to look over his spending, meaning he could still enter into contracts, he could still work, he could still vote. He couldn't spend all the money he had to people who wrote him letters and asked for it. We'll go to the next slide. So back in the beginning, I said it's much more difficult to get a guardianship, and we'll go through the appointment process real quick. And again, I'm going to go through this pretty quick. Nobody cares really too much about the procedure of a guardianship, I don't think. You can ask questions if I skim over something, but it's a court case. And I tell everybody, if you watch TV, you've heard of plaintiff and defendant. So just to be difficult, let's just get rid of those. In Virginia, who's traditionally the plaintiff is called the petitioner, and who's traditionally the defendant is called the respondent. You'll hear those two terms throughout the process. And then another term that most people have heard of, if they've heard of it, it's a guardian ad litem or a GAL. And that is, and we'll get to it in a minute, but that's the eyes and ears of the court. And I say, if anybody's ever heard of it before, people generally run across it in child custody cases. So if they or a daughter or son has ever been through a divorce, the court and they had children and that was an issue, the court appointed a guardian ad litem for them. But getting back to the appointment process. So again, it's a petition. We've gone over that you'll be the petitioner or the respondent. You can petition for anyone over 18 years of age to have a guardian and conservator or conservator appointed for them. And if it's a child with a disability, you can petition when they're 17 and a half. And that just is to make sure that there's no time gap during the court process after they turn 18, that nobody's in there to take the place or of their decision making. This is more for parents who are guardians over their and conservators over their children, or anybody really can ask for a standby guardian. I mean, I can ask for my sister to be the guardian of my child as a standby if something was ever to happen to my wife and I. So it'd be my wife and I as potentially co-guardians. And then upon our incapacity or death, my sister would then step in without having to file another court hearing. She would have to just to go down to the court and change some paperwork. I see this a lot of time. The next one, petitioner does not have to be the person seeking appointment. Lots of times, we'll go back to what I do. At Oast and Taylor, I do the litigation. In an elder law firm, people will ask, well, what's that? About 50% of it's guardianships. And then I'd say split those into 50%. So 50% of the guardianships would be people who just failed the plan. The other 50%, so it'd be 25% of my total work, would be people who planned and something has gone wrong. At the beginning, I told you that an advanced medical directive or a power of attorney normally take the place of a guardianship, and they do. But sometimes people have agents that aren't acting in their best interest, or they have documents that weren't, I'll say, professionally prepared, and they don't allow the person seeking the guardianship or the incapacitated person to have the decisions made that need to be made. One of the classic misses we see is the power of attorney won't allow the sale of real property. Another one we see is the power of attorney is actually, unfortunately, and I'll go back to the 50% of my guardianships, is actually a bad actor, meaning it's a neighbor that's come over or an abusive, and when I say abusive, I don't necessarily mean physically abusive, but financially abusive, either relative, grandchild, or again, bad actor, neighbor. Lots of times we see it with caregivers also will appoint themselves agents under the power of attorney, and then they'll start moving and transferring assets either to joint accounts in their names, or they'll be the payable on death beneficiary, or one of the big ones we see is they slowly use that position to ice out or exclude family members and isolate the senior. So in that case, you could have had your power of attorney done, and the new agent or the new bad actor is then making bad decisions and using that as a vehicle to abuse the incapacitated or elderly individual. And in that case, then you would have to step in for a guardianship and conservatorship. So now, why I said, got off on that tangent, why that's important is lots of neighbors see this. So a neighbor will come in and say, you know, I'm friends with Mr. Jones across the street. I know his caretaker is taking advantage of him. He's asked me for some help, but I don't want to get involved. And when I tell people that, like, you have to be involved a little bit, but they can be the petitioner, meaning they can come to me, they can file, but they don't have to be the guardian and the conservator. There are a couple organizations in our area that will do that for them. Jewish Family Service, Catholic Charities, some law firms do it. They'll step in and they'll be the guardian conservator. And then everybody's going to say, I'm going to say a question I'm going to get, whether you want to ask it publicly or not, is who pays for that? And the code, and I'll say most attorneys, if it's a good case, and what I say good case, it's bad for the incapacitated person, but the facts are there, the attorney feels that they would be successful. The code, and when I say the code, it's Virginia law allows the incapacitated person's estate to pay back the petitioner. So that, you know, if you don't have, even though you're a good person, lots of people don't want to go get on the hook for tens of thousands of dollars to an attorney for their neighbor. So again, the code allows the neighbor to be paid back or just pay the bill, depending on how the attorney enters that. The guardian conservator can be the same person or different people. I've already covered that. And you can have two people, meaning you can have co-guardians and co-conservators. I used the example with husband and wives. I'm married to my wife. We have 3 children, and if something happened to where we would have to be the guardian conservator, we'd probably be the co-guardians and conservators in that situation. So I've caught up now to the slide we're on. I've covered the GAL, and I've basically told you what they were in the context of a divorce. But again, they're the eyes and ears of the court. So it's an attorney. They're required to take what we call CLE, or a special class, to teach them how to be a guardian. And then they need to, I think, work with a guardian a couple times, and then they'll get on a list where they're approved in different cities. Different cities have different people approved. Lots of people are approved to act as the guardian ad litem, excuse me, in the whole area. And they will be appointed by the court to go out and do a home visit. They also, when I keep saying the code, but state law is the code. The code requires them to do, depending on how you count it, a list of 5 or 6 things. And it's mainly, they're a shield for the incapacitated person. Overall, the guardianship process strips the incapacitated person of their civil rights. It can allow them not to vote. It can allow them not to sell real property, own firearms. Their driver's license will be revoked, at least temporarily. And that's a pretty big deal. So the court takes that seriously. They don't want, just when I say the court, the judges don't want a 10-minute snapshot of what's happening. They need, and the legislature agrees, they need a person to, again, act as a shield. So the guardian ad litem will go out and visit. They'll put their eyes on the person. They'll tell the person their rights. And when I say tell them their rights, the incapacitated person, again, going back to how complicated this process is compared to planning, has the right to a jury trial. They have a right to put on evidence. Again, it's, if you watch TV, leave alone the petitioner, respondent, and plaintiff defendant distinction, but it turns into, or can turn into, what you see on TV. You can have depositions, you can have court hearings. It can be a pretty extensive process. So again, the guardian ad litem's job in that situation is to not call balls and strikes, but again, to write a report and give their opinion. Importantly, and we see this come up a lot, especially nowadays with the weird court schedules because of COVID, the court signs the order. When I say the court, the judge signs the order and appoints the guardian and or conservator. Afterwards, though, they cannot act until they qualify. And what I mean by qualify is they then have to go to the clerk's office. The clerk swears them in, and it is raise your right hand, and they pay some fees, and then they've been appointed. Then they're appointed and can act, and they get what's called a certificate of qualification at that point. And I tell my clients, when you go to the banks and the other places, take your order. But what they really need, and when I say they, it's the banks, the doctor's offices, or anywhere else, they need what's called a certificate of qualification. It's a 1-page fancy sealed document that the clerk's office prepare. And when you do that, that allows you to act. We'll skip to go to the next slide, and that's duties. And I've kind of touched on it a little bit throughout this, but these are the duties. And again, why I said, so we've gone through the court process, which is, again, more complicated and complex than having an agent appointed. Now we have your duties. Other than taking care of the individual and making sure they're cared for, and I'd say that both financially and physically, you have different duties required by the code. And one of them for the guardian is to file an annual report with the Department of Social Services. I think out of both of these that are on this slide, that's the easier one. It's a couple page, I think, PDF that you basically say, here's where they are. There have been some changes since last year. There haven't. Here's who's caring for them. Here's their address. For example, if they're in a nursing home, you disclose that and you say that the nurses are giving the care that the incapacitated person requires. The conservator, though, is a little or a lot more complex. When I told you that you qualify, when you qualify, the clerk appoints what's called a commissioner of accounts. Commissioner of accounts are attorneys in each city that have been appointed by that city or circuit court, meaning the judges in each district or circuit get together and decide what commissioners they're going to have. For example, in Chesapeake, we have 2. Portsmouth, I think, has 2, and the Beach has probably 7 or 8. But anyway, they're attorneys with special training. And what you do as a conservator, I tell all of my clients, and I think it's good practice, you never take out cash. You never use a debit or credit card, and you write checks for pretty much everything. Now, nowadays, there's some places that you can't write checks to. I understand that. And you can fix that through direct deposit or with a letter. But when I say a letter to the commissioner explaining what that charge was for and have a receipt. But either way, you have to account for every penny in and every penny out. As you can probably imagine, that's a very responsible position, and some people unfortunately take advantage of it and use it for their own gain. And that's the next bullet point: is a surety bond is required. And what a surety bond is, it's basically insurance. A third party comes in, Liberty Mutual, there are a bunch of third parties, but they come in and they say, okay, we're going to insure this and provide a insurance policy is what it is, that if the conservator runs to Mexico with all the incapacitated person's money, the commissioner of accounts, if things are working right, will catch that. And then the company will come in and replenish the money that was taken. So it's an insurance agent it's an insurance policy for the incapacitated person, and we'll end up paying out. But again, that is more expense. You're talking probably a couple $100 a year at a minimum out of the incapacitated person's estate to pay for that insurance policy. We talked again about the specific acts you can do. Selling real estate and gifting, those are probably two of the bigger issues that come before the court with conservatorships. If everybody is on the same page, and when I say everybody, I mean the incapacitated person's children, and there's not fighting, I will normally ask in my court orders for just the blanket power to sell real estate. Some cities like that and some don't. If not, when I keep going back to the code requires a multi-step process to sell real estate, meaning you have to get it appraised, list it with a licensed real estate agent, and then submit all that to the commissioner of accounts, who then can approve or disapprove the sale. And then they get back to you. And as you can imagine, if you've ever tried to sell any real property, that scares away a lot of buyers, whether rightfully or wrongfully. The buyers don't like to hear, oh, I made an offer on this house I want to buy from you. And the seller, who would be the conservator at that point, answers, well, let me see if it's okay with court. And the better the market is, and when I say the better the market is, the faster houses are selling, the more that'll scare away buyers. So again, with a properly done document, which Jessica will get to in a few minutes, you could skip through all that. And then we'll go to my final slide, which is tailing right into Jessica coming up here. I put durable power of attorney in AMD. Well, DPOA is a durable power of attorney, and AMD is advanced medical directive, and a guardianship and conservatorship, and I've touched on it a couple times. The paperwork, the power of attorney in the AMD, they preserve the individual's independence. It's who they picked, right? They go to Jessica next week and say, I saw your presentation. You're much better than Brad Brickhouse. We're going to go ahead and get our paperwork done, so we never have to see that guy. When they do that, they or you are in charge. They're picking who they want to be in charge. No civil rights have been stripped away, meaning they're still allowed to independently enter into a contract, vote, they can marry, they can drive. In a perfect world, if I had an advanced medical directive drafted, I would give it to my agents. And that's what we mean by streamlines the decision-making process, meaning they're ready to step in it. And then I tell clients, if you have an advanced medical directive, go ahead and get it filed at the banks now, because when it's filed at the banks now, if something then happens, they can go to the bank and act, and you're not chasing the bank trying to pay bills for somebody that's in the hospital. The guardianship and conservatorship, again, it's the last resort, but it's the heavy hammer, meaning if you do have a power of attorney or advanced medical directive, I've touched on it before, and I just said the positives are that you're still independent. Well, that's also a negative. Sometimes if a person's being abused or making bad decisions or being swindled, having them be independent is not what you want. And then you have a bad actor. Again, I'll give you generalizations, and what I see is lots of times nowadays you'll have a child in California, a child in Maryland, and it's not that they're bad kids, they're out in California, Maryland. They still check in with their parents, but now you have again, I'm putting in quotes, a helpful neighbor that comes and tries to start severing that relationship, and then they end up there. Then we find out, oh, now they're the agents under the power of attorney or advanced medical directive, mostly the power of attorney. And in that situation, that again, that independence is a bad situation. You don't want the parent to be able to be independent because they now have a person that is influencing them to make decisions that aren't in the best interest of the parent. So again, a guardianship and conservatorship solves that. But like I said at the beginning, we hope that you're never in that situation. It also revokes legal rights. Now, we talked about how heavy-handed it is. It does revoke those things, but if for some reason the person regains capacity, so say they're a younger person and it's not a progressive disease, but they were in a car accident and they were in a coma or incapacitated for a month, and decisions had to be made during that time, you can restore them back. We had a client who had I think he was 20 and was in a motorcycle accident and had a traumatic brain injury. But recently we have restored his guardianship. So we dropped the guardianship, meaning now he just has a conservator that helps him with his monthly budget, and more we kind of turn over more and more responsibility to him to see how he'll do. And hopefully at the end of this year, early next year, we'll file a petition to have his rights restored as a conservator too. And then the legal incapacity. We've talked about what being we haven't talked about what being incapacitated means. In the goal in the realm of guardianships and conservatorships, I would tell you this is not the legal definition. That doesn't make sense to most people, but it's they can't care for themselves anymore. It's a significant issue, and they cannot care for their health, safety, or therapeutic needs, meaning they're either giving away so much money that they're going to become homeless, or it's so out of bounds that clearly a normal person wouldn't do this, or that they physically deteriorated to the point that they can't care for themselves anymore. And unfortunately, we see that with lots of people who don't want to go into the continuum of living. And when I say that, assisted living and or nursing homes. So then they'll isolate themselves in their home and they need some help. And I put this as the last one, is poor judgment alone is not sufficient proof of incapacity. That's actually in the definitions of the state code, meaning just because someone makes bad decisions, and trust me, I make them, everyone makes them, does not mean they need somebody to come in and make better decisions. I think what I and the code are trying to get through with that is it needs to be a significant problem that impairs their function and standard of living almost to the point of safety before you can step in and have someone declared incapacitated. And with that, well, I'll wait till the end and we'll do some questions, but we'll turn it over to Jessica. And again, if you listen to her, you should listen to her, and it keeps you from ever having to need a guardianship or conservatorship. So I appreciate the time.
All right, if we can have the next slide. Thank you. I'm introducing Jessica Hayes. She's an attorney with Wolcott Rivers Gates in Virginia Beach, and she does estate planning in addition to powers of attorney. She also handles wills and trusts, and I believe she assists clients with administration as well. With that, I'm going to turn it over to Jessica, who will go over powers of attorney.
Great. Thank you so much for having me. I appreciate it. Let's go ahead and advance to the next slide, please, Debbie. Thank you. So we'll go ahead and start with general durable powers of attorney. Brad began going over this. He gave you a good overview. I just want to hammer home the point that what he was just discussing, the guardianship and conservatorship process, really is the last resort, and there is a way to avoid it. I'm a planner. I know a lot of people are planners and just like to know that they have their affairs in order. When people think about estate planning, they usually think first about having a will or maybe a trust and who's going to inherit if they pass away. But estate planning is so much more than just figuring out what's going to happen after your death. There's some really good incapacity planning that can be done to try and avoid that guardianship and conservatorship procedure in the event of your incapacity. So I think one of the most important documents to have in an estate plan is a power of attorney. And the reason for that is because in Virginia, if you become incapacitated and you don't have a power of attorney in place, there is no default decision maker who can step in and start handling your affairs. A pretty common misconception that I hear is, well, I'm married, so if something happens to me, my spouse will just take care of everything. And while you might have joint bank accounts where your spouse could use the money to keep paying your bills and handling things that basically both of your names are on, that is limited only to those joint assets or joint accounts. Your spouse could not, for example, pull money out of a retirement account for you if you became incapacitated and did not have a power of attorney. They couldn't, I don't know, change a beneficiary if they found that there's no beneficiary named on a life insurance policy that you own. Your spouse couldn't do that. There are several things that your spouse can't just automatically do because they're your spouse. They would need to have a power of attorney in place to be able to assist you. So you want to make sure you have that. I'll start with some terminology here. So on the first slide, we're defining the principal is the person who creates the power of attorney. So that's me. If I'm signing a power of attorney, giving away the ability or giving someone else the ability to help me with my financial affairs, I'm the principal. The agent, or sometimes you'll hear attorney in fact used, that's the person who is named to assist the principal in handling their affairs. Note that if you sign a power of attorney and you name an agent to help you with your finances, you're not giving away any power. You're just sharing the power to handle your finances. So unlike with the conservatorship, where the person who has a conservator appointed to manage your financial affairs, to manage their financial affairs, where that person loses the ability to do it themselves, if all you've done is sign a power of attorney, you've said, well, I'm going to keep handling my financial affairs right now, but I'm also naming this person who can assist me. So it's almost like having a clone walking around. This is generally a broad document that lets your agent do almost anything that you can do, with the exception of voting or writing a will. Those are the two big things I can think of that your agent can't do for you. It can be very limited or it can be very broad. So sometimes we'll have maybe a person who's going to be out of the country when there's a piece of real property to be sold, and they'll sign a limited power of attorney specifically for the sale of real property. It can be limited as to a specific act or limited in duration. I've had clients request a limited power of attorney so someone else could manage their business if they were unable to, but it's just specifically that one thing. More commonly, what I see is people who want broad, general powers of attorney that lets their agent do just about anything they could do. In Virginia, there are a handful of powers that only apply in your power of attorney, though, if you spell them out. And attorneys, we call them hot powers, just that's our jargon, I guess. But those powers are the ones that they're kind of superpowers. They give your agent a little bit more power than you might have otherwise expected, but sometimes it's really necessary for them to use that power. So, for example, the ability to make a gift, the ability to change a beneficiary designation, so who you've named as beneficiary on your life insurance policy or retirement account, or maybe you've made a bank account payable on death to someone and it needs to be updated. And also the ability to create and transfer assets into trusts. Those are some of the bigger powers that definitely have to be spelled out in that power of attorney in order for them to apply. And when I have this discussion with clients, we're talking about whether or not to include those broader hot powers. Sometimes I get the question, well, why would I want to do that? Often those powers are helpful when a client needs to go apply later on for Medicaid, which is a means tested public benefit, or maybe for aid and attendance, which is a veteran's benefit that helps pay for assisted living facility or higher level of care. That's also means tested. If you've given your agent the ability to make gifts, that might be something that's helpful to help you qualify financially for one of those benefits, Medicaid or aid in attendance. On the other end of the spectrum, I've had clients who had significant assets, and we realized after they became incapacitated that a large retirement account, for the one client I'm thinking of right now, a very large retirement account did not have a beneficiary designated. And we were going to have some pretty severe tax consequences if there was no beneficiary designated when he passed away. It would have been very helpful if his power of attorney had included the power to change beneficiary designations. And because it wasn't included, we actually ended up having to petition the court to get a conservator appointed specifically so they could change beneficiary designations. So it's really important that the power of attorney is broad enough to meet your needs. This is not a document that you want to have prepared on LegalZoom or to just find another form online or one that someone's given to you. It's something that you really want to work with an attorney who can evaluate your needs and your family's needs and make sure they include exactly the right provisions so that if someone does need to help you at your incapacity, they can. Now, the last bullet point on this slide talks about springing powers of attorney. A power of attorney can be effective either immediately when it's signed, or it can be what we call springing. And springing means that it only goes into effect at your incapacity. And in order to determine whether someone's incapacitated, we would need a doctor's note saying the doctor has examined you and that you can no longer handle your financial affairs. So your agent would not be able to do anything under that power of attorney if you've made it springing until they have a doctor's note saying that you need the help. Okay, we can go ahead to the next slide, please. You know, I saw some questions pop up in chat. I'll address those at the very end, if that's okay with the rest of you all. So let's go ahead to advanced medical directives. Switching gears, I just talked about the financial power of attorney. The advanced medical directive says who's going to help make your medical decisions if you could not. There actually is a default rule in Virginia if you do not have an advanced medical directive. It says that if you're married, your spouse generally can make your medical decisions. If you're not married, it goes to your children. So if we've got children who are going to fight over it, we might have a problem there. It goes further out the family tree. So if you don't have a spouse or children and you need help making your medical decisions, they'll look to see, do you have living parents? Do you have living siblings? It just goes further out and out until they find someone. Now, for the for the advanced medical directive, in Virginia, we split that document up into two main sections. And sometimes you'll hear these sections used interchangeably, or if you go online and do a search about advanced medical directives, you might get really confused about the lingo. Medical power of attorney and living will are often used instead of advanced medical directive. Really, the medical power of attorney is the section in a Virginia advanced medical directive where you say who it is that could help you make your medical decisions. And you're appointing, again, they're called an agent to help you with those decisions. They can only assist you in Virginia if two doctors have examined you and determined you unable to make your own medical decisions. So a little bit different than a financial power of attorney. This document is not immediately effective. You don't have the option of saying it's immediately effective as long as you are able to make your own medical decisions. If you have the capacity, you're the only one who makes your own medical decisions. If two doctors have examined you and said that you're not able to anymore, that's when the advanced medical directive kicks in and the agent you've named can start making decisions for you. That person can also help with organ donation. That is something that I usually ask my clients about, and will include a provision that either says they can assist with organ donation or they can decline to do any organ donation. The second section in the advanced medical directive is called a living will. And that is where you get to say what kind of end-of-life treatment you would want if you had a terminal condition and no reasonable chance of recovering, or if you were in a persistent vegetative state. Basically, you're so far gone that there's no real hope of you coming back. A lot of times my clients say, give me no extraordinary measures. I wouldn't want the machines, no ventilator, no feeding tube if there's really no real chance of me recovering. But give me comfort care and painkillers just to make me more comfortable during that process. Sometimes I do have people who say, give me all you got. I don't care how much it costs. I want every opportunity. And that's fine too. So we want to make sure that if you have a strong opinion about what kind of end of life treatment you would want, you put it in writing. And the biggest benefit this document has for a lot of families is it relieves the burden from your loved ones, from feeling like they've had to pull the plug on mom. You don't want them faced with a tough decision or trying to figure out what it is you would want. If you know already what it is you would want, go ahead and put it in writing. Make them feel like they understand your wishes. They can review this document. If something does happen and it needs to be used, they're following your wishes and not making that decision themselves. Next slide, please. So the next slide really applies to both powers of attorney and advanced medical directives. It is critical that whoever you name as your agent in these documents is the best choice for you. I would not just by default name the child who lives with you to handle your finances if maybe they're there because they filed for bankruptcy before and they can't afford their own home, or just think through who in your life you can fully trust to step into your shoes and act in your best interest if you could not. If it's for the financial power of attorney, you want to make sure that they have good financial sense, that they have basic knowledge of finance, tax law. They've been filing their tax returns, so they're likely to help you file yours if you need the help. They're really going to take care of you that way. And of course, you want to make sure that you completely trust that they're going to act in your best interest. They're not going to abuse the authority that you're giving them, and that they really are the best fit for this job. Now, whoever you've named for the financial decisions might not make the best decision for the advanced medical directive. So they might not be the agent you want making medical decisions for you, and that's fine. I have some clients with children who, one child's a nurse, another one's a CPA, and it's pretty clear who should be named first in each of these roles. So for the medical decisions, maybe you've got someone in your life who is great. They're familiar with medicine. They'd make a really great advocate for you if you were lying in a hospital bed and you weren't getting the proper treatment. You want that person really in that role, helping represent you. If there is no one you can think of in your life who'd be great to put in that role, you can name an independent fiduciary. There are banks and trust companies that might serve in that role. Attorneys might serve in that role. I've seen law firms named. In some situations, the people or the organizations that might be willing to serve as conservator might be willing to serve under a power of attorney. There are other options. So if you can't think of anyone in particular, definitely you want to go a little bit further. Try to talk to an attorney for some ideas and we can help you out. If you have named one person in your power of attorney to serve as your agent or in your advanced medical directive to help with your affairs, and they leave the country or something else happens to them, we also want to make sure that there's a backup named. So try to think of maybe 2 or 3 individuals or fiduciaries. Fiduciary is just the person who's looking out for you. Make sure that you have at least 1 or 2 backups. Just in case the person that you've named first in line is not able to assist. Again, let me reiterate, these are not just forms that you find online. You really want to work with an attorney to make sure that the document you end up with is one that really reflects your wishes. It says what you think it says, and it's going to best serve you if you need the help. Thank you.
All right, we have received some questions. So the first question was actually for Brad Brickhouse. If you can come back on your video, and Jessica, if you want to hang out on your video as well. there's some questions for you. And so the first question was, can a guardian be someone who lives elsewhere out of state?
Oh, yes. The short answer is a guardian and conservator can live out of state. They'll have to get what's called a registered agent, which is no big deal. Their attorney will probably do it for them. And all that means is if there's a lawsuit, someone can be served. But the short answer is yes. But I tell clients nowadays you can live in Hawaii and be the guardian conservator, someone in Virginia, but just make sure you have some eyes and ears locally that you trust so they can fill you in so that you can make the decisions you need to make.
All right, thank you. Jessica, the next question is for you. If a couple does not have a power of attorney, does the surviving spouse have an instant power of attorney?
So use of the term surviving spouse makes me think we're asking about at the death of one of them. So a power of attorney is actually only valid while the person who signed it is alive. And at their death, it's no longer valid. The person who is named as agent cannot keep using it. At that point, it's really the executor of the estate that's going to be stepping in and handling the finances of the person who passed away. So that's a great question. Thank you for asking that.
The next question is, what can someone do if a power of attorney is obtained and the client does not have capacity?
This actually may be a great one for Brad because we probably have, I'm going to guess, dueling power of attorney concerns. There's often litigation involved. So Brad, I'll turn that one to you.
All right, I'm going to assume by the question that it means something bad's happening, meaning I don't think if everything was working, I'll say it's not this nuclear family where mom and dad are taking a decline and mom gets a power of attorney for dad and the kids want her to act, but you know, they're not sure dad had capacity. So I'm going to, in that case, less is probably more, but I'm assuming this isn't the case where it's clearly some elder abuse going on. And to answer that, that's when a guardianship and conservatorship is needed, because I think legally you can revoke, or the agent, the incapacitated or potentially incapacitated person could probably still revoke the power of attorney, but you're just going to get into what we call, I think Jessica called it, dueling power of attorney or dueling revocations, and then you're just in this back and forth ping pong match over who's in charge. So at that point, that is when where a guardian conservator would be appointed, and we would put in the order that all powers of attorney or advanced medical directives are revoked, and then procedurally you would have to tell the agent or the bad actor whom you think has the power of attorney that's suspected. You would have to tell them that you're doing that and make them a part of the proceeding.
All right. Jessica, if a power of attorney is signed in another state or a state, and then the principal and agent move to a different state, do they need a new one? So I guess the question is whether or not powers of attorney carry over state borders.
So it is not absolutely required if you move to a different state that you sign a new power of attorney. But it's a good idea, because if someone tries to use that power of attorney in your new state and it looks different from what the banks or whoever it is that you're presenting the power of attorney to are used to, they might have problems getting it accepted. Legally, as long as it was valid when it was signed, the power of attorney is probably still valid in the new state, but I think it would still probably make me feel better if I move to a different state to know that a bank is going to accept whatever it is they're presented because they're used to seeing it. So I'd recommend getting a new one. At the very least, have an attorney look it over in that new state and get their opinion.
Okay, we have one other question. How can you resolve or cash in checks from Social Security and a few other refunds written to a person after they die if you're the sole beneficiary in their will and they were power of attorney while they were alive without establishing an estate, as the bank wants, even though resolving the rest of the person's affairs only required going to the clerk of court to get the will certified, given the value of the overall holding? So did you, guessing that's a small estate question.
Okay, so we have checks written to the person who's passed away. Power of attorney, obviously not good anymore. My first question would be, how much are the checks worth? What else is in the estate? If the total value of the estate is less than $50,000, there is a process. It's considered a small estate, like Caryn mentioned, but basically you record the will, 60 days have to elapse since that person's death. And you present a small estate affidavit to the bank to try and access those funds or whatever small assets there are. And that's something that I definitely would recommend you speak with an attorney about. Make sure that they can help ensure that you've gone through all of the steps necessary, and then create the small estate affidavit to access those funds. If it's more than $50,000, you definitely want to speak with an attorney about what's necessary in order to handle the estate.
Okay, we got another question. As a contingency, since the gentleman already has a power of attorney on a family member, what form should be obtained if a need for executor of the estate becomes necessary? As requested by the homeowner, I've been getting the home ADA ready. I don't know if you want me to unmute the gentleman so he can ask.
I think I know what we're getting at here, but feel free to type more, or you're welcome to unmute him if you'd like. So basically, like I said, the power of attorney ends at death. After someone passes away, it's the executor of the estate that really steps in and handles your financial affairs, wrapping everything up and administering the estate. Now, what document appoints the executor? That's going to be the will. And in some cases, we also have a trust. So a trustee serves, but let's go basic will plan. That person needs to qualify before court after the individual has passed away. And that's a whole other presentation, I think, but they'll want to not only have the power of attorney in place so you can assist them during their lifetime, but also to sign a will that names you as executor. So if they want you handling their affairs after their passing, you can be that person.
Well, I have browsed the will, and that's been a few weeks ago. And I just saw that where I was listed as one of the beneficiaries. And the will was prepared well before 2014. That much I do remember. But the person I have last spoke with the other day, and just that their capacity right now to support themselves physically by, standing or whatever. Their person's somewhat wheelchair or bedridden at the moment, hoping to get better, to be able to walk and move or stand at least. That way that person can get back to being able to take care of themselves. They had someone renting a room that partially helped out. And the only problem with that person who was doing good, except she ended up passing away. And her mail is still coming in. She's still getting this, still getting that. And I've responded to some of the billers that to let them know that the person has passed. I acquired a certificate of death, which I'm sad to say that the certificate of deaths I had been seeing of years earlier, and the one that I was able to acquire did not list the cause of death. I just left the place of death, the date of death, and what funeral home or this or that, whatever that was on those certificate of deaths, I haven't seen yet. So, I mean, it's not on it. I don't know when that law or whatever changed, but I am extremely curious on that, but I haven't had the opportunity to research it. So basically, I'm trying to continue to get the work done. And I also have several other issues I have to deal with in addition to that. But very soon, that person will be released to come home. And we're trying to get, I don't know how long, 24/7 nursing care, or at least 40 hours a week. And getting this paperwork out of the way is another hassle with that the home the convalescent center and myself are trying to do. I'm trying to get other documents that people are not going to email, but they're supposed to be sending. It wasn't in the mail yesterday, but I'm hoping to get there soon. So am I still going in the right course, or do I need to keep going or step up a little bit?
I want to make sure that I understand the question. So is the individual who will be coming home is the person you want to be able to act for?
That's what I've been, I'm doing that now. I have the POA, but I'm presuming that that person is going to be getting better to come home.
Okay.
Mhm.
And you want to make sure that if they pass away, you can continue handling their affairs?
Even if I have to do it with a co-sibling of mine, yes, of ours, because it is a sibling.
Okay. And it sounded like there's an existing will in place.
Yes.
Okay. So do you know if you're named as the executor of the estate in that will?
No, I do not recall.
Okay.
I know that at the time of the will, the individual was married, but there was a situation between them. They had separated, and hunting some other papers, I found a will that he prepared, but I didn't read it yet. They both had a will prepared, I guess separate wills prepared at the same attorney's office.
Okay.
So,
Probably a good idea to meet with an attorney to have that reviewed. And if that person you're speaking of is available to meet with the attorney, that would probably also be helpful. You're welcome to give me a call, or probably any of us, for assistance with that, and we can address it, make sure that I'm getting all the facts.
okay. Now, one thing is I'd like to get a copy of the slides that were shown so I can look back at it and later review it, even if it's electronic. So
Debbie, you can make those, I think, available on your website. So we will definitely look into getting those slides put on the senior services website. We did get a couple other questions in the meantime. There was a question about, is a person who has power of attorney required to be a resident of Virginia? The short answer to that is no. So the other question was, in Virginia, can you handwrite and have estate papers notarized to be legal?
I strongly recommend against it. All of these documents, the will, the advanced medical directive, the power of attorney, have different requirements for what it takes in order for it to be valid. The advanced medical directive is the easiest one to meet those requirements. It just needs to be signed by 2 witnesses, but you need a notary for the power of attorney, and it's a good idea to have notary and a couple of witnesses for the will. I have seen it go wrong more than I would like when there have been handwritten documents used, and it ends up costing the family and the estate a lot more money to deal with if it's been done that way. So even though there is some expense involved in getting the documents done professionally and properly, at least you can have peace of mind knowing that it's done correctly. So I wouldn't recommend trying to do it yourself.
All right, well, that was the last of our questions, and our hour is up. But as I said, first I'd like to thank Brad Brickhouse and Jessica Hayes for being our speakers today and for all this helpful information. Senior Services hopefully will be able to put this PowerPoint up on their website. And then, you know, I had provided Debbie Schwartz's email. If you still have that, it's in the chat. You can email her some questions if we didn't cover them today, and she will forward them to me. And if we can answer them, we will. So thank you everyone for attending, and enjoy the rest of your day. All right.